Good afternoon. We thank you for joining us today. We're going to give folks just another minute or two to jump on. We do have a large number of registrants, and I want to make sure that everyone has the opportunity to join us. Thank you for your patience.
Good afternoon and welcome to Going Viral, COVID-19's impact to employee benefit plans and more of your Secure Act questions answered. So initially this was going to be a follow-up call to some of the Secure Act questions that we've been getting in the Secure Act webinar that we co-hosted a few months ago, but my how a lot has changed. So the focus of this webinar will be on the litany of different rules and implications for benefits related to coronavirus. We will also, though, circle back to the Secure Act as the last part of our presentation to go through some of the questions that we've gotten since our last webinar and some of the questions that we've been getting from plan sponsors and partners alike. So an introduction to the co-presenters today. Ann Tyler Hall, this is me. We with Hall Benefits Law. And our team over the past few years has helped companies avoid and abate over $60 million in ERISA penalties. And we work towards a proactive, relationship-driven employee benefits legal compliance approach for our plan sponsor clients across the country. Our next presenter is Bonnie Treichel, and she is the co-founder and partner at ZUNA. They focus on strategic consulting and advocacy for institutional retirement plans and their stakeholders. She is also the immediate past president for the ABC of the Great Northwest, vice chair of ABC's nationally, member of the other American Retirement Association committees nationally. She is a member of the State Bar of California, and we've enjoyed working with Bonnie here at Hall Benefits Law. To give you just a brief overview of the agenda today, we're going to first focus on coronavirus and retirement plans and some of the impact of COVID-19 to employer contribution modification considerations, participant distributions, specifically under the CARES Act and changes to loans and hardships, and then additional CARES Act and other considerations for employers. Then we're going to turn to a discussion around coronavirus and health and welfare benefits, and specifically legislation related to coverage mandates and COVID-19 screening and testing, and then also a discussion around the CARES Act and changes thereunder for telebenefits. We're also going to talk about HIPAA privacy in the COVID-19 environment and protecting protected health information under the HIPAA privacy rules, and then other plan design considerations related to coronavirus and various health and welfare benefits. The next part of the presentation will look at coronavirus and executive compensation and some employer considerations for cash and equity compensation plans and Code Section 409A considerations. And then finally, we're going to turn back to the Secure Act and specific questions and answers related to particular provisions in the Secure Act. If you have any questions, there's a great deal of information to cover today. If you have questions, please email us at admin@hallbenefitslaw.com or bonnie@teamzuna.com, and we would welcome your questions. Or you can post a question here to the forum here in the webinar. So with that, we'll dive in and look at some employer contribution design considerations in the context of COVID-19. So there have been a lot of furloughs, discussions around furloughs, and obviously COVID-19 has had already a significant impact on our economy. And with that, employers are making some tough decisions around do we roll back, for instance, our employer contribution in our retirement plan to potentially save jobs or prevent required furloughs or other implications. And so if you are an employer and you have a safe harbor plan and you are considering making a change to that or suspending your safe harbor contribution, a couple of notes to make is that generally mid-year suspension is only permitted if you're operating in an economic loss, which is defined very specifically and narrowly, or you have provided already an annual notice that specified the right to suspend or reduce your mid-year your contributions, employer contributions mid-year. And so with that suspension is required a supplemental notice, and that supplemental notice must include the following information: the contributions being suspended, an explanation of the consequences, how participants can change their contributions, and when the suspension or reduction takes place. Generally, notice must be provided at least 30 days prior to the effective date of the suspension. There are some exceptions to that 30-day requirement, but those are narrow. And we recommend that you consult counsel if you're looking at a swifter mid-year suspension to your safe harbor contribution design. If you are an employer with a discretionary employer contribution design, you have a little bit more flexibility. Employers can suspend or reduce discretionary contributions, generally for any reason, and no supplemental notice or amendment is required. But there are anti-cutback considerations, and so again, it's important to consult with counsel, with your advisors, about the implications of suspending any type of contribution mid-year. And just a note, if you have, for instance, a last day or 1,000 hour requirement for your discretionary contribution, so the employee must be employed on the last day, or they must achieve 1,000 hours of service prior to being eligible for the employer contribution, you generally can retroactively suspend or reduce the employer contribution to the beginning of the plan year. If you don't have that allocation requirement, you generally can only suspend the discretionary contribution on a prospective basis only. Looking at from the participant perspective, so we looked at this from the employer perspective, some considerations for employers and mid-year employer contribution suspensions. Now looking at this from a participant perspective, maybe you are a participant who has been furloughed or lost a job. What are your options for obtaining funds from your, for instance, company's 401k plan? And so generally under your 401k plan, distribution events are limited, although termination of employment, death, disability, those are the traditional distribution events. There are, however, also permissible in-service withdrawal events. And for instance, if you are age 59 and a half or older and your plan permits withdrawal, That is a permissible in-service withdrawal with no early withdrawal tax, no early with 10% withdrawal tax. Your plan may also permit loans and hardship withdrawals. This must be specifically permitted in the plan, and Bonnie will talk about the special provisions in the CARES Act related to loans and hardship withdrawals. And you can also, depending upon the terms of your plan, plans do sometimes allow for distributions upon completion of a certain number of years of service. But the 10% early withdrawal tax applies if those amounts are withdrawn prior to attainment of age 59 and a half. With that, I'm going to turn it over to Bonnie to talk through the CARES Act implications for retirement plans.
Great. Well, thank you so much, Ann Tyler, and thank you to your team for coordinating today. It's always so exciting to get to present with you. So as Ann Tyler was just going through the traditional options that are available to your plan as it relates to both what employers can be doing from a plan design perspective, as well as what you can do for your employees traditionally from a plan design perspective. Now, I'm going to turn our focus to what's available under the CARES Act, which passed on March 27th. And it's crazy to think what's happened since March 27th. There's been a lot of different activities since then. So I'm going to jump into the CARES Act and cover some of the provisions. And when we think about the CARES Act, from my perspective, it really did things for your employees, but for the most part, the CARES Act doesn't really do a lot for employers. And what I mean by that is that it's going to have two main provisions that open up access to funds for employees, but it doesn't do a lot for employers. And there's still a lot of advocacy going on to try to change some provisions or to make different changes so that employers can have opportunities to delay notices, delay filings, and even have some changes around things like those safe harbor contributions that Ann Tyler was talking about a moment ago, but none of that has actually happened yet today. So when we talk about the CARES Act, most of this is relating to the ability for your employees to access funds in the retirement plan. So as I mentioned, this passed on March 27th, and I'm going to cover specific to retirement-related provisions. And there's a couple of key things when I talk about these provisions that we want to keep in mind. So first, from a timing perspective, the CARES Act started immediately, and it started on March 27th. The second thing we want to keep in mind is that this is permissive. And what I mean by that is, as an employer, you get to decide what you adopt and what you don't adopt. And so you want to consider not only this immediate impact for your employees, but also the long-term impact on the retirement plan. And Ann Tyler is going to talk a little bit more about some of those considerations. We also, third, want to keep in mind different time frames. So when I talk about expanded loans versus the distribution options that are available, they have different time frames. So you want to keep that in mind. And then finally, we want to think about qualifications. So this isn't just available to all employees. You want to keep in mind the different, quote, qualifications or eligible employees. And I'll tell you what that means here in a moment. So as I go ahead and change to my next slide, if I do this right, there we go. So the CARES Act, what it really does is two main provisions allow greater access to the funds for your employees. The first is what I refer to and what the CARES Act refers to as a coronavirus-related distribution, or for short, I'll call it a CRD. And I distinguish that from a hardship, and we'll talk about that a little bit more here in a moment. The second big provision is expansion of loans. And so that's going to provide greater access to the loans, which you may already have available in your plan. So there's some real practical considerations that we want to keep in mind. And again, Ann Tyler is going to go into this a little bit more, but when I think about it, and in dealing with it just here over the past couple of weeks, the team here at ZUNA has really recognized that there's different capabilities as it relates to service providers. And so you want to have very, very strong communication from a practical standpoint between service providers, and that includes both the TPA and the record keeper, as well as the client. And so a couple of just quick examples to keep in mind are that this is permissive, as I mentioned, but some confusion starts to occur with the opt-out provisions that some of the record keepers are using. So they'll send out a notice that says, you must elect this by X date. There's no certain date that you have to opt in or opt out under the Act. That might be something for administrative or operational purposes that various record keepers are trying to stick to, but that's not something under the Act that you must do or must not do. It is just an opt-in, or it is permissive rather, and so that's at your option, but that's more of an operational or administrative efficiency thing to just keep in mind. So again, really keep strong communications as you work with your outside counsel, someone like Ann Tyler, as well as your record keeper and your TPA. The other thing you'll want to keep in mind is both your internal, just operational procedures to make sure those stay up to date. And again, I think Ann Tyler will speak to that a little bit more specifically. So the next thing we want to keep in mind is who can actually avail themselves to these provisions, provided that you actually have that as a part of the plan provisions. So the Act only extends to a, quote, qualified individual. So what does it mean to be qualified? To be qualified, there's three ways to qualify. Either one, the individual has been diagnosed with COVID. Two, their spouse or dependent was diagnosed with COVID. Or three, there's a whole list of adverse financial consequences that would qualify. And so I've summarized a few of those on the slide, but it's, you know, you've had reduced hours, you've been laid off, your business is closed, something related to childcare, any of those things would qualify. And then also the Secretary of Treasury has the authority to expand upon that list. So if any of those things qualify you as an individual, and then the plan has adopted it, then you may be able to access the CRD or the expanded loans. So we'll go ahead and dig into a little bit more what that actually means. So the first option that's available under the plan, if it's adopted it, would be a coronavirus-related distribution. And what is that? Number one, it would be the Act defines a coronavirus-related distribution as a distribution up to $100,000 in aggregate that would go to, it would have to come from an eligible retirement plan, which could include a 401k, a 457, a 403b, an IRA. Specifically, defined benefit plans would not be qualified to take out a coronavirus-related distribution from. Number two, it must be taken during 2020. So it's all of 2020. So that's the second thing to keep in mind. Third, it must go to the qualified individual, which is what we just talked about on the prior slide. So we want to keep in mind that it's $100,000 in aggregate during 2020, and that could be taken out in multiple distributions from the participant. So one of the things the team at ZUNA has been talking to clients about is that we don't want to encourage people to take the entire $100,000 because of the long-term consequences on the plan. So it can be really beneficial to encourage them to only take what they need, and then if they need to come back, they could take it out over multiple distributions that eventually can lead up to the $100,000, but they don't have to take it all at once. It could be in multiple distributions. Another distinguishing characteristic about the CRD is that it doesn't have to be repaid, but it may be repaid. And so if it's going to be repaid, it would need to be repaid within 3 years, but it doesn't have to be repaid. So keep in mind that the CRD is different than a traditional hardship. It does not have the 10% penalty. It is based on self-certification. So if the individual says, yes, I qualify for one of those three things we talked about on the prior slide, that's based on their own self-certification. And finally, it can be paid back. So I'll go ahead and turn it over to Ann Tyler, who's going to talk a little bit more about some of the plan sponsor considerations related to hardships and distributions.
Thank you, Bonnie. And so just a point to make that the CARES Act does permit plan administrators to rely upon the participants' self-certification that they are a qualified individual. But to your point, Bonnie, it's important that participants be, or that employers be communicating with service providers, because there will need to be an affirmative election by the employer, or opting in to this provision by the employer, and a modification then to withdrawal forms necessary to accommodate these coronavirus related distributions. And then generally we would just say it's a best practice to preserve source documents evidencing the need, distribution request related to coronavirus. Again, it's a self-certification, but as a best practice, it would be advisable for employers to recommend to participants who are availing themselves of this coronavirus related distribution as a qualified individual to preserve these documents evidencing that this need or distribution request was related to coronavirus and satisfied the provisions of the definition of a qualified individual. And then it's always important for employers to review their vendor contracts to determine which guarantees and indemnification provisions apply to vendor performance. We were quite concerned about this earlier on in the COVID-19, kind of mid-March, when it wasn't clear to us if some service providers might implicate a force majeure and be unable to, because of their own furloughs or their own remote working paradigm and the adjustment thereto, might have to implicate a force majeure clause in their service agreement, and wouldn't be able to fulfill their obligations related to these changes. But that does not seem to be as present day a concern. We haven't actually seen that play out. But that is it is an inflection point with your service provider to make sure that you are in communication, that you make the appropriate elections or the opt-in for this provision under the CARES Act distribution alternatives, and that you opt in to those provisions. And to your point, Bonnie, we had read or heard that one of the service providers, very large service provider, record keepers, this CARES Act became effective, was signed into law on March 27th, and they were requiring employers to notify them if they were going to make this affirmative election to opt in to the CARES Act distribution provisions by March 31st. So I'm not sure that that was a reasonable time period in which to make that decision. But to the point, this needs to be communicated with your service providers, your record keepers, and done in a timely fashion.
Great point. And we were experiencing, certainly across the various record keepers, a variety of different timeframes as early as March 31st, and then some that are much later. So I think very great points there. So with that, we'll go ahead and move on to the second major provision that allows employees the opportunity to access funds in the retirement plan, which would be the expansion of the loan provisions. So again, the thing we want to keep in mind here is that this is another permissive option. So it's up to the plan sponsor to decide if they would like to add this provision or not, in line with what we were just saying. And one of the other things that I think Ann Tyler will discuss more on the next slide, again, is keeping in mind the loan policy of the plan and the plan's governing documents. So keep that in mind with everything I'm about to explain. So we all know that there is, under the IRS limits, there's existing limits for loans. So typically that would be the lesser, and this would be for an individual to take a loan, it would have to be the lesser of $50,000 or 50% of the vested account balance. And so that has been increased to $100,000 or 100% of the vested account balance. So a much larger amount that's going to be available in the form of a loan. Going back to what I said a few slides ago, when we keep in mind the timeframes are different for the CRDs as opposed to the loans. So this applies to loans that are taken for 180 days following March 27th, when we had the CARES Act start. So in other words, for any loan from March 27th through loans taken up until September 23rd, 2020, this new higher amount would apply only if the plan sponsor elected to add this to the plan. Then the second thing that is, again, permissive applies for those who've already taken a loan. So if you think about it, this is kind of going on all over the place. Think about with any auto loans you have, your mortgage, things like that. There's all these opportunities to say, hey, we get kind of a pause on our repayments. And the same applies here if the plan sponsor adds it for all outstanding loans taken from the retirement plan. Loan repayments that are due will be delayed for 1 year. And then likewise, that kind of repayment time frame, let's say it was supposed to be repaid in 5 years, that just gets scooted out a year. Keep in mind, though, interest will continue to accrue on those, but the duration of the loan, as I mentioned, will get extended. So those are the two major changes on loans that are now available under CARES if added to the plan. And so I'll go ahead and turn it back over to Ann Tyler to talk about some of the considerations that plan sponsors would want to keep in mind.
Thanks, Bonnie. So some just employer considerations with respect to the loan expansion under the CARES Act. This applies generally regardless of the changes to the CARES Act, but retirement plan fiduciaries are charged with carefully ensuring that the loans in operation adhere to the terms of the plan governing loans. So we see a lot of plans with separate loan provisions, and so this again is a good inflection point. You have the existing loan, if you're an employer that already allows for loans, making sure that those loans that are outstanding comport or comply with the new updated guidance via the CARES Act. And then employers who are taking advantage of the CARES Act expanded loan provisions generally must amend their plan to accommodate these new rules. And it's advisable that they provide clear communications to participants that delineate the new loan criteria so that participants are clearly aware of what the contours of the expanded loan program under the CARES Act are. Employers who elect to amend their retirement plan to allow for the CARES Act must ensure the new limits and requirements are properly applied in operation. So even though there's been some expansion, some flexibility to the loan provisions for coronavirus-related loan distributions, there are still and requirements around loans, and we see as a compliance issue non-compliance with the loan provisions, either in the plan document or pursuant to the code. And a lot of employers have non-compliance issues related to loans. So just a reminder that the underlying loan rules still apply, and although there is an expansion through the CARES Act, there still needs to be adherence to these new contours of the expansion of the loan provisions. And then for loans unrelated to coronavirus, employers are still responsible for enforcing loan repayment schedules. Obviously, there's been a delay for loans for the next period. But once that period ends, then the loan repayment schedules must be adhered to.
Great. So now we're going to turn our focus a little bit away from somewhat all of the provisions under CARES for employees. And I'm going to take back a little bit of what I said earlier, that CARES does nothing for employers. And I'll touch on just briefly a hit and run of a couple of the things related to CARES that are for employers before we shift gears a bit. So real briefly, for defined benefit plans, there are a couple of quick things that CARES does for employers. The first is related to a delay of required contributions. So a company can delay until January 1st, 2021, any required contributions that would otherwise be due in 2020 to meet funding standards. So the benefit is that this provision will provide cash-conscious companies with the ability to conserve their cash in 2020, obviously. The caution to employers, though, is that interest must be paid on the amount of the delayed payments. So that's one thing to keep in mind. That's a benefit under CARES for defined benefit plans. The next area I would draw your attention to is the student loan provisions that really got tossed in, I'll call it, to CARES. So one that is somewhat unrelated to retirement plans but related to student loans is there's Section 3513, which is somewhat of an extension from the Department of Education guidance. And so this allows through September 30th for no federal student loan repayments and no interest on federal student loans. So that's somewhat related, and you can perhaps relay that to employees and be a hero for them if they don't already know it, which I'm guessing that they do and are excited about it. But the one that really I think got kind of tossed in and has been considered for quite some time is Section 2206. And that allows you as an employer to pay up to $5,250 per employee on student loans for each of your employees. And that can be done on a tax-free basis. And so it includes payment for any education-related costs. So this had been, I think, considered in various other forms of legislation for a while. This provision is specific to 2020 alone, but it is likely, I would say, I shouldn't say likely, it is possible that that will get extended beyond 2020. So for those organizations that do have the extra resources to potentially be able to do something for their employees later in the year, this could be something for consideration. The other thing that I'll mention that was done, hopefully, fingers crossed, for employers was the ability or the opportunity of expanding the Department of Labor's authority under the CARES Act. And so the Department of Labor was granted some broad authority to expand deadlines for various notices. They have not acted on that authority to date, but the hope is, I believe, that for some of your required notices that the Department of Labor will end up using their authority to take some action and help employers later on, particularly given all of the remote workforce, and that the default for some of these notices, of course, is still by snail mail and paper, and that's very difficult for some employers right now. So that's one thing to stay tuned and see if the Department of Labor will eventually use some of that authority. The next thing that we'll move on to is just a couple of other quick items that were under CARES, and one of them relates to RMDs. So again, this is really helping out individuals. When you think about how RMDs get calculated, that's based on the market value at the end of the prior year. So if you can imagine, when you think about values, 12/31/2019 as opposed to present, under the CARES Act, it waives the requirement for any RMD that is required to be taken in 2020. So that's delayed for a year. And kind of think about this when we come back to talking about some of the questions under the Secure Act. We'll come back to this and how it does tie into some of the changes under Secure that related to RMDs. The last quick piece I'll just touch on under CARES before I quickly hit on one other thing before turning it back over to Ann Tyler is related to HSAs. I only put this under this section briefly, given that a lot of people use HSAs as a retirement savings vehicle. So we just want to keep in mind that HSAs were expanded under the CARES Act to cover over-the-counter medication and mental care products. And so there was quite an expansion of HSAs. And I think Ann Tyler might touch on that a little bit more as well under her section. So aside from the CARES Act, one thing that Ann Tyler, I know, is tracking and has done some great articles on, and our office is tracking as well, is relief beyond CARES in the form of extensions and other regulatory guidance, as I mentioned, hopefully coming from the Department of Labor and from the IRS, and then also from the PBGC. So I've just noted a couple of various extensions. They're here for your reference. I'm not going to spend time going through them, but of course continue to watch for many more of these will likely be coming. And with that, I'm going to turn it over to focus more on the health and welfare side.
Thank you, Bonnie. So I'm going to tick through these slides fairly quickly. Please do, though, email if you have any specific questions, admin@hallbenefitslaw.com, just to give us sufficient time to review the Secure Act questions. But the COVID-19 has had implications not only to retirement plans, but health and welfare benefits and executive compensation as well. Wanted to touch on just a few of the changes, updates under recent bills, under recent legislation in the health and welfare benefit plan arena. The first relates to what we affectionately call FFICRA, Families First Coronavirus Response Act, was passed, became effective March 18th. And essentially, it broadened the coverage of COVID-19 screening and testing so that most plans now, pursuant to the FFICRA and the CARES Act, require first dollar coverage of coronavirus testing and screening. The FFICRA specifically defined approved coronavirus testing and screening as those tests and screens approved by the FDA. The CARES Act expanded that even more, and we'll talk about that in the next slide. But the plans then, health plans generally cannot impose cost sharing, prior authorization, or other medical management on this coverage. The idea was to allow as many participants or individuals as possible to have access to COVID-19 screening and testing. Just a reminder, too, that we'll be sending you a copy of these slides. So if we rush over an issue, don't have sufficient time to answer your question specifically, we will be sending out these slides following the presentation. So in addition to the FFICRA, then the CARES Act further expanded the definition of covered diagnostic COVID-19 testing to include those tests beyond those that were FDA approved. And it also, the CARES Act also clarified that plans and insurers must reimburse coronavirus testing at the same rate previously negotiated before the emergency declaration. This change, this update, is a material modification to health plans and must be then accommodated via ERISA required disclosures, including the summary of material modifications. Generally, the SMM must be provided within 210 days after the end of the plan year in which the material modification was adopted, but we recommend that you provide it well in advance of that deadline to allow your participants to be on notice that the COVID-19 testing is covered. Prior even to the passage of the FFICRA and CARES Act, in mid-March, the IRS released Notice 2020-15 as one of the first pieces of guidance that we got related to COVID-19 and health plans. But the IRS made it clear that a high deductible health plan would not lose its status as a high deductible health plan, and therein participants would not lose their tax advantage through their HSA contributions merely because an HDHP, a high deductible health plan, covered the cost of testing for treatment of COVID-19 before the statutory minimum high deductible health plan deductible was met. And so this was important guidance because if a high deductible health plan does not adhere to the deductible requirements and the first dollar coverage limitations, then it can completely disqualify the high deductible health plan. We've had plan sponsors in that situation. So some nice relief, nice guidance from this IRS notice in mid-March that plan sponsors could elect to modify their high deductible health plan design. Now, there was some discussion around this for the self-insured plans and whether carriers would work with plan sponsors to allow for this first dollar coverage. But again, CARES Act, the FFICRA then required that both fully insured plans and self-insured plans offer first dollar coverage for COVID-19 testing and screening. In addition to the expansion of COVID-19 testing, not only for those testing and screening FDA approved, the CARES Act also made clear that high deductible health plans could cover telehealth services pre-deductible without causing loss of HSA eligibility. And this is effective through December 31st of next year, 2021. The CARES Act also, as Bonnie alluded to, expanded the allowance of HSAs and health flexible spending accounts, FSAs, to be used to pay for over-the-counter medical products. There's no expiration on that, so a real expansion then of HSAs and health FSAs and what those dollars in those accounts can be used for. CARES Act also expanded and included that and allowed that HSAs could pay for the monthly fee up to $150, $300 if more than one individual is covered, to a direct primary care physician. And so again, this was aimed at promoting remote and telehealth care. And easing the restrictions on first dollar coverage. Again, SMM, a summary of material modifications, is likely required for these telehealth changes, and we do recommend that summary material modifications go out sooner rather than later, and not 210 days after the end of the plan year. But to alert participants to these new rules and the expansion of telehealth provisions and first dollar coverage for COVID-19 testing and screening. In the context of the economic considerations related to COVID-19, we've had a lot of employers ask us about group health plan eligibility and when do participants in the health plan lose their group health plan eligibility. And generally, events that cause loss of eligibility are termination of employment or reduction in hours. And those are enumerated COBRA events. But for instance, if an employer puts an employee on a furlough, or if the individual is on family and medical leave, then those leaves are generally protected for purposes of group health plan eligibility, and an employee would continue to be eligible for health benefits under the group health plan. Just a note that there are a myriad of considerations related to benefits eligibility structure, as well as considerations regarding layoffs and furloughs that impact benefits eligibility. We've been talking with plan sponsors on a regular basis about their specific facts and circumstances and how those implicate health and welfare benefits, retirement plans. So just a point to be made that there are a myriad of considerations as it pertains to furloughs, layoffs, leaves of absence, and benefits. Did just want to raise the point about HIPAA privacy and security. And so as background, generally, the HIPAA rules apply to covered entities. Employers generally are not considered covered entities, but their group health plans are. And so HIPAA privacy places strict restrictions on the use and disclosure of protected health information, generally defined as someone's name, phone number, social security, any type of personal identifier, and health status. And so just a reminder for employers that HIPAA protects this PHI. And so in the employee benefits context, PHI is information from the group health plan. As it relates to COVID-19, it's important for employers to remember and to take into account HIPAA considerations that may arise if an employer finds out about a COVID-19 diagnosis through the group health plan. There are permitted uses and disclosures of PHI without an individual's consent, and that includes treatment for treatment purposes, payment or healthcare operations to a public health authority for purposes of preventing or controlling a disease, to persons at risk of contracting or spreading the disease or a condition of another law, i.e. a state law. But again, it's important to remember as an employer that PHI can only be shared in limited circumstances without the participant's consent. So if you're an employer with an individual with a COVID-19 diagnosis, as it pertains to sharing information from the group health plan, you are still governed by the HIPAA privacy and security laws and the contours therein. We wrote an article recently on some considerations around plan design and COVID-19, specifically as it relates to disease management programs, wellness programs, fringe benefits, leave sharing. And so check out our article published on law360.com about some plan design considerations, some health and welfare benefit plan design considerations related to coronavirus. So I'm going to briefly just talk about employer considerations as it relates to executive compensation, because COVID-19 has had a significant impact across all areas of benefits and all aspects of benefits of businesses, including executive compensation plans and programs. So for restricted stock, these full value awards that have significantly now gone down in value, employers may want to consider issuing additional awards for realizing the intended long-term incentive value, or granting cash settled units to ensure the intended value of the long-term incentive award is realized. For stock options and stock appreciation awards, employers may consider resetting the awards based on the current lower stock value, taking into consideration that the economy, it's not completely clear what will happen as the year progresses with the economy. And so employers may want to also consider a wait and see approach, and but also whether resetting the awards based on a current lower stock value makes sense even now, and making sure that with these considerations that employers are taking into account the ripple effect and disclosure requirements, accounting implications of these changes. Employers may also want to consider issuing new awards based on the current lower share price in the context of appreciation awards. For participants in these executive compensation programs, Section 409A is a great concern, and the reason it is such a concern for executives and participants in executive compensation programs is that non-compliance with Code Section 409A implicates, in addition to the ordinary income tax, a 20% excise tax for non-compliance. So someone in the 35% tax bracket and that receives a non-compliant payment from a deferred compensation program would then be subject to an additional 20% excise tax plus interest. And Section 409A applies to all compensation earned in one year and paid in a later year. And it can include compensation and severance programs, employment agreements. We even have a client that we've worked through on a settlement payment, and the settlement payment was not exempt from Code Section 409A. And so the settlement agreement contemplated installment payments over a period of years, and those installment payments had to conform to Code Section 409A. So any compensation earned in one year, paid in a later year, generally considered deferred compensation and subject to Code Section 409A. And in the context of coronavirus, COVID-19, and economic environment in which we are now living, a lot of questions then around what types of events would allow for a distribution from a deferred compensation program. And so for purposes of separation from service, there is a specific explicit definition under Section 409A. And so the question you as an employer must ask is this individual, have they truly severed from service? It's reasonable to believe that no further service will be performed, including as an independent contractor. If an executive has been furloughed and it's expected that they'll come back within with the ensuing months, that's not a separation from service for purposes of 409A. That's not a distributable event. Important for employers then to make sure that as executives are requesting or they're looking for funds and resources during this economic downturn, that employers stay aware of the rules and requirements around Code Section 409A and the definitions that apply and what specifically is considered a separation from service. Also, we've seen employers asking about unforeseeable emergency. That's also a permissible Section 409A event, but it has a specific definition. And so employer office closure by itself may not rise to the level of an unforeseeable emergency. Demonstration of a resulting hardship from a company closing or office closure may indeed constitute an unforeseeable emergency, but very important that that the also had employers ask us about planned termination and making that difficult consideration. Just wanted to remind employers and those who work with employers with deferred compensation programs that if an employer does in fact decide to terminate a deferred compensation program or a program subject to 409A, during the first 12 months after the action to terminate the plan, distributions must only be made when they would have normally occurred. And an employer may not adopt then a similar kind of non-qualified plan until at least 3 years after the plan termination date. Also, a reminder about substitutions and the prohibition on employers substituting, for instance, a new agreement that alters the time and form of payment of an original agreement. So with that, I'm going to turn it back to Bonnie.
Great. Well, thank you, Ann Tyler. I think so what we're going to do with our remaining time is try to just quickly hit on as many questions as possible that are a follow-up from the Secure Act. If everyone can go all the way back in their brains to December of 2019, when we had the Secure Act that really kind of slipped in right around the holidays. And keep in mind that these slides are going to be made available to you as well as the recording. So I'm going to probably just skip ahead a few slides and get to our first question. And what we've done is you also have available to you the recording and the slides. Feel free to email us if you have any questions on how to locate those so that you can see the full overview of the Secure Act and all of the information about every single provision that was included if you need to track that down. We've whittled that down to just some select questions that were asked as a follow-up. So what I'll do is just hit on those questions and then a brief answer to each of those questions. So keep in mind that the Secure Act, it passed right at the end of the year, December 19th, 2019, and there were several different provisions. The goals of the Secure Act were really to expand coverage so that more people could have access to the retirement plan, and also to address longevity concerns so that people weren't outliving their retirement savings. So the Secure Act has a variety of provisions, and what you have to keep in mind when reviewing them is things such as the timing of when these various provisions started, if those provisions are permissive or mandatory, because many of those are mandatory. You don't get the choice for these provisions like you did with the CARES Act we were just talking about. And then figuring out, do these provisions actually apply to your plan? So for example, some of them apply to 401ks, but they don't apply to a 403b, for example. So I'm going to skip past several of these slides, but again, they'll be available for you. And go ahead and look at our first question. So I think earlier, what I mentioned is that with RMDs, keep in mind that you're going to start to see some crossover, even though the Secure Act seems like you probably filed it so far back in your head. When you look at an RMD, for example, you want to keep in mind the crossover between the CARES Act and Secure. So we know that with Secure, it increased the date for commencing RMDs from retirement plans and individual retirement accounts from 70.5 to 72. And so that allows money to grow tax-free for another year and a half. So one of the questions after the last webinar was, if an individual is retired and turns 70.5 in January, and we believe that was January of 2020, can he or she take out an RMD? So we want to keep in mind that secure changes apply to those that reached age 70.5 after December 31st, 2019. So for those that were 70.5 on December 31st, 2019 or prior, they had an RMD due for 2019. And then also keep in mind that for these people, the CARES Act waiver is going to apply. If, however, you turn 70.5 in January 2020, so you were born after July 1st, 1949, then Secure will apply to you and your RMD won't be due until age 72, and so the CARES Act waiver isn't even applicable. So Ann Tyler, feel free to jump in if you have any additional thoughts, but the answer to this question is that it does apply to you and it pushes it off if it was in January.
Yeah, and it's interesting because I read this as they actually wanted to take the RMD, but your description is correct, Bonnie, that generally under the Secure Act, then they would be part of that group of individuals where the new RMD would be age 72.
Yes. Yep. Great. So we'll go ahead and move on to the next one. If we think back to Secure, one of the new provisions is that there is this penalty-free withdrawal option for birth or adoption of a child. And so that allows a withdrawal up to $5,000 within 1 year following either the birth or adoption of a child. So one of the questions that's come up is, what proof is required of the birth or the adoption? And to my knowledge, the proof is really on the part of the employee. I think this question was getting at, hey, what does the employer need to actually understand if the baby was born or there was an adoption that took place? And my understanding is that for tax reporting purposes, it's the employee who's going to identify this when they go to file their taxes, and that the instructions were updated for 2020 for forms 1099-R and 5498. And so those instructions have been updated, and that's where you will identify that. Another question that was asked is, how is the money paid back? So one of the provisions here was that you don't have to pay this money back, but you do have the option if later you want to pay the money back to the plan, for example. I'm still unclear, and Ann Tyler, feel free to jump in if you disagree, but I don't think there has been any additional guidance at this point as to, number one, the time frame you would have to use to pay the money back if you determined you wanted to do that, or exactly how that would be handled on the tax return. I don't think that there has been any additional guidance from the IRS yet, but I would anticipate there may be at some point, although certainly things around COVID have taken precedent.
Yes, and I did just want to note that each parent can separately apply for the $5,000 and be eligible. So presumably a family then could be eligible for then up to an in-service withdrawal, assuming that the employer allowed that under the terms of each of the respective spouses' employer retirement plan, could for their family withdraw up to $10,000. For birth or adoption.
Great.
But I agree, Bonnie, I think there is a lot of question, and we'll hope for guidance around the repayment provisions. And that also applies, I think, for the coronavirus-related distribution, the 3-year payback. Not entirely clear how that's going to, the mechanics or the logistics around that.
Agreed. Great point. Yeah, a lot of parallels there and the need for guidance. The next one we'll move on to is the tax credit for small employers. As we know, one of the things under Secure was this encouragement of getting more small employers to have a plan or to start a plan. Unfortunately, I would argue that when you start to look at the small print around it, then you see that the tax credit isn't as widely available. And so one of the questions is there a tax credit for a company that has an existing DC plan but starts a DB plan, or vice versa? Or one of the things that when you really start to look at it is that if there is already an existing plan that that entity has, and it could even include a simple IRA. So if it's a 401k, a DB plan, a simple IRA, if there's any plan within the last 3 years that that company has, then by starting a new plan, you do not get to avail yourself of the tax credit. So that does certainly start to whittle down the number of folks who can avail themselves to the tax credit. Another question came up: if a company uses plan assets to pay for startup costs, then can they avail themselves to the tax credit? And again, the clarification there is no, of course. If you're using plan assets, you do not get the tax credit. It has to be that you're using corporate assets to pay for startup costs. And there's a pretty wide definition of what those startup costs are. They can be expenses of establishing the plan, administrative expenses, participant retirement related educational expenses. So you can broadly define that probably to pay for several things related to the startup of that plan, even including maybe the record keeping expenses, TPA expenses, advisor expenses, etc. But those have to be coming from corporate assets. You can't use plan assets and then get a tax credit for that. The next one, and I know we're a few minutes over, but we're about to wrap up here, so we'll just quickly hit these last few. The next one that we'll just quickly hit on here is related to the elimination of the stretch IRA. And the question here just really related to, we all know that the stretch IRA was eliminated, and the question was, is that only specific to IRAs, or does that also apply to plans? And that does apply if it's coming from a plan as well.
I think that's an important distinction or addition, is that it's not just IRAs, Bonnie, but also retirement plans in general, tax qualified employer retirement plans.
Yes, yeah, great point. Yeah, it's all of the qualified plans. The next one that we'll hit on relates to the prohibition of part-time employee exclusion. And so this is the one where we're really expanding the coverage or availability for individuals who are long-term part-time employees to be able to put their own money into a retirement plan. And when we're talking about part-time, so this is those who are working at least 500 hours per year for 3 consecutive years, then they get to put their own money into the plan, as opposed to they're not entitled to the employer contribution, but their own money. And so the first question comes as, does this apply to 403B plans? And the one thing that we know is 403B plans, they already have their own universal availability provision. So this does not apply to 403B plans. The next question is related to how will the prohibition on exclusion of part-time employees impact smaller employers? And Tyler, you might have, kind of your own thoughts on this. My thought was that it only applies to long-term part-time employees. So I think I don't perceive that it has any substantially greater impact on smaller employers, because it's only the employee's own money. The only really difficult part is just the cost of the administrative portion, that it does become difficult to track hours sometimes.
I think the biggest implication there, Bonnie, will be that smaller employers will now be required to have an independent qualified, an IQPA, an auditor's report to accompany their Form 5500, because they will be over that generally 100 eligibles threshold. With the inclusion of these long-time, part-time employees in eligibility now, I think we're likely to see many more employers who are, maybe in that 80 range of eligible employees currently in their employee count for their retirement plan, beginning with this, the effective date of this prohibition on part-time employee exclusions, which begins next year. The counting of the 3 consecutive years of service. But I think in 2024, we may see a not insignificant spike in smaller employers that now are subject to the IQPA to accompany the Form 5500.
That's a great point. That's an excellent point. And then the last question that we'll end on relates to if same topic here, but if a 401k plan currently allows all employees to participate for purposes of deferrals, how is this going to impact testing? So is the plan allowed to exclude these employees for purposes of non-discrimination testing? And, again, Ann Tyler, feel free to weigh in if you disagree. My reading is that they can be excluded for testing if they're solely in the plan for purposes of long-term, part-time reasons, but certainly weigh in if you disagree with that. The last kind of piece that we just want to hit on, now that we've covered the overview of the Secures Act questions from last time, we just wanted to leave you with a couple of kind of thoughts and action items as we close out. So the one thing we want you to help wrap your head around is we've talked about Secure Act, we've talked about CARES Act, and then Ann Tyler also raised a lot of issues around plan design. So we want to help you to think about when you need to make your plan document amendments. So we'll leave you with this slide. Definitely feel free to reach out with any questions as to the timing of when you would make those plan document amendments, and certainly how you could do that. You'll also definitely want to be communicating with your service providers on that as well. I'll go ahead and leave you with these action items and turn it back over to Ann Tyler to close out our presentation today.
Thank you so much, Bonnie. Yeah, I think we want to be a resource. I know Bonnie and ZUNA, myself and Hall Benefits Law, there are a myriad of changes, there are a myriad of considerations. There were prior to COVID-19, prior to coronavirus, but this has added a level of complexity, and we want to be a resource for plan sponsors and service providers to navigate these issues as they arise, and every employer and every plan is unique and different. So, and every employee demographic. So we just encourage you as you make these decisions to seek guidance from your service providers, ERISA counsel, consultants to assist you in your evaluation of legislation, regulation, and associated guidance. And we do appreciate you joining us today. Please, again, don't hesitate to send your questions to admin@hallbenefitslaw.com or Bonnie@teamzuna.com. Thank you so much.